Greetings, peace, love, and law to every one of you. I'm going to be reading the section here in Suits of Chancery in the part of who may be sued in Chancery in Article 2. I'm going to be reading sections 86, 87, 88, and 89 in this video. Thank you again for watching and following. I hope you're enjoying the content and learning along the way. So I'm going to start. 86. General rule as to parties defendant. In general, it may be stated that every person who may sue in the Chancery courts may also be sued. And in addition, all persons who may or must sue by guardian or next friend may be sued, for they cannot plead their disability in their defense. The only persons, natural or artificial, who cannot be sued are the state of Tennessee. The state of Tennessee cannot be sued. Alien enemies residing out of the state in time of war. Foreign executors and foreign administrators can't be sued. And public corporations created by and in another state for governmental purposes. Okay, because I'm guessing they have immunities. Okay. It is sometimes said that bankrupts cannot sue or be sued. The reason for this, their estate, by operation of law, has become vested in their assignees. And they, therefore, cannot legally sue or be sued because they have no interest in the subject matter of the suit, and no decree can consequently be pronounced against them. What is meant by bankrupts not being able to sue and not being subject to be sued is that if they sue, no decree can be rendered in their favor. And if they are sued, no decree can be rendered against them, if the fact of their assignment or discharge duly appear. But if a defendant fail to plead the bankruptcy of the complainant, or fail to plead his own discharge in bankruptcy, the suit will proceed as though no bankruptcy existed. Man, is that what's happening right now? Because all these corporations are technically bankrupt. There's no real money. It's just all promissory notes. And I mean, I guess the only thing that is of value is when the company receives the rights of people, and that is value itself. So I wonder if that still falls under the category of being bankrupt. Interesting. But this is interesting, though. Again, it's the more I read this, is basically saying that if somebody brings something to court that normally, court would not really allow it to be, or the rules would not allow it, but the other party fails to make mention of it, well, it will proceed as if it's okay. And I think that's what's happening in the courts when we don't object to the whole predicament we're in there, and they're just not explaining the nature and the cause of the issue that they're bringing forth. I mean, they're just saying, hey, you're being charged, you're either guilty or not guilty. You know what I mean? The word innocent isn't even mentioned there. They just say guilty or not guilty, and state your name. So they're already treating you as in such a way that there's presumptions, and I guess that's where we must be making our objections to that and asking questions. Anyway, 87. Suits against infants and lunatics. Minors, married women, and persons of unsound mind may be sued, but as they are incapable of defending a suit by themselves, they must make their defense through others not under any disability. Minors and persons of unsound mind defend a suit by their regular guardians, if they have such. But if they have no guardian, or if the guardian is a complainant or is adversely interested, they defend by a guardian ad litem, appointed by the chancellor or appointed by the master for that purpose. Where a minor is also a married woman, it is nevertheless necessary that she should defend by a guardian ad litem, the practice being to appoint her husband to be her guardian ad litem when he is a co-defendant and there is no conflict of interest. Perhaps, however, a failure to have a guardian ad litem appointed for a married woman who was a minor but who jointly with her husband is answering the bill would not make the proceedings void as to her, if it appeared that she had full defense made for her, as was in no way prejudiced by not having a guardian ad litem. In such a case, her husband would be, no doubt, be deemed a de facto guardian ad litem. Okay. Section 88. Suits against married women. In regard to married women, ordinarily their husbands must be joined with them as defendants in suit. And their answer must also be joined. There are exceptions, however, to that rule in both of its requirements. A married woman may be able to defend and answer as a single woman, as, for example, whenever her husband is complained in the suit and sues her as defendant. For in such a case, he elects to treat her as a single woman for the purpose of the suit. But generally, a married woman cannot answer separately when her husband is joined, or ought to be joined, as a defendant in the suit, without an order of the court for that purpose founded upon special circumstances. Thus, where a married woman is sued in respect to her separate estate, or where she claims as a defendant in opposition to her husband, or lives separate from him, or disapproves of the defense which he wishes her to make, she may obtain an order of the court for liberty to answer the defend the suit separately, and in such a case her answer may be read against her. If a married woman obstinately refuses to join in a defense with her husband, the latter may obtain an order to compel her to make a separate defense. If the husband has, upon leave, answered separately, the wife may, upon order, afterwards file her separate answer. If the husband be abroad and not answerable to the jurisdiction, the complainant in the suit may obtain an order that she shall answer separately. Except under circumstances of this and the similar nature, a married woman can defend a suit only jointly with her husband, unless she is living separately from him in some of the case stated in a preceding section. But if she is engaged in the mercantile or manufacturing business in her own name, or by an agent, or as partner, she may be sued as femme sole. I think that's like a sole proprietorship, femme sole, for the debts incurred in the conduct of such business, and no plea of coverture will avail in such cases. Where the married woman is also a minor, she must defend by guardian ad litem, as before stated. But if a married woman is sued as a single woman and fails to plead her coverture, the judgment or decree against her will be valid and may be enforced against her general property, but not against her separate estate. That's interesting. That is very, very interesting. This is, where is it again? 14, huh? Let's see. Mentions a case file. Okay. Case. Okay, anyway. Section 89. Suits against counties, cities, and other corporations. Names stand for the things named, and we know things by their names. The law recognizes this and allows all persons, natural and artificial, to be sued by those names whereby they are known. Counties are sued by their statutory names, as Shelby County, Davidson County, Knox County, and the like. Cities and incorporated towns are generally sued by their corporate names, being the name given to them in the act or charter of incorporation. But as the complainant may not know the exact corporate name of a city or town, he may sue it by the name it is generally known by. Thus, if its proper name be the mayor and city of Nashville, the city may nevertheless be sued as the city of Nashville. Private corporations may be sued by their corporate names or by the names by which they are generally known in the community where they do business. The officers of a corporation may be made defendants along with their corporation and required to answer under oath when a discovery is sought. Wow, okay. So there's a footnote right here in 15. That has to do with this right here. The law recognizes this and allows persons, natural and official, to be sued by those names whereby they know. When a name is mentioned, if we know the person or thing, his or its image, characteristics, and personality at once rise up before our mental vision. Thus, names are the symbol of things. Nomina sunt symbola rerum, and is, as is said in Coke, nomina si sperit cognitio rerum. If you know not the name of things, the knowledge of them is lost. The law deals with things and persons by the names they are known by. 16. Corporations, like other persons, are supposed to know their baptismal name. What? Corporations, like other, are supposed to know their baptismal name? Okay. Alright, so but third persons are not. And so third persons may sue a corporation as well as a natural person by the name by which it or he is generally known in the community. What the hell is he talking about? Baptismal name. Corporations are supposed to know their baptismal name. Third person are not. Huh. Maybe I'm missing something. Okay. So, that was it right there. That was section 86 to 89. It's tripping me out. This thing of baptismal. What the hell are they talking about? But let's read this part right here. It is sometimes said in our reports that a misnomer may be taken advantage of by plea or in abatement in the Chancery Court. No decision to that effect can be found by the author of this work. Okay, alright, now there you go. So I'll be reading this in the next video, which are going to be general rules as to parties, principles applied in determining the proper parties, so on and so forth. It's going to be 6 sections in the next video. And thanks again for watching. Thanks again for joining along. And hope you're learning. Hope you're finding this super interesting. And again, this is a treatise in suits and chancery, setting forth the principles, pleadings, practice, proofs, and processes of jurisprudence of equity, and giving numerous illustrative forms, pleading, writs, orders, reports, decrees, and other proceedings in suits and chancery from their beginning and their end, by Henry Gibson. Until next time, peace, love, and law.